Hello and welcome, aspirants. So, we are here with another topic from the KGS magazine. The last month there was a very important observation that came from the Supreme Court, and that was something related to presidential reference. It was in the form of a presidential reference, and today we are going to talk about it. Okay. So, first, let's understand the context in which we are now discussing this topic. The context, as you can see, it is related to the Supreme Court's recently delivered an advisory opinion on the 16th presidential reference, which means the president made a reference and the Supreme Court deliberated upon it. The Supreme Court accordingly gave a decision on it, but we don't consider it to be a decision or a decree of the court. That means it's not a judgment of the court, because as we know that it is something which is only advisory by nature, not binding. Okay. Now, what exactly was this about? So the role was primarily related to the timeline which is there for the president or the governor to frame their decision on a bill or on the bills which are passed by the legislature, state legislature. It goes to the governor, and it may so happen the governor may refer the bill for the or reserve the bill for the consideration of the president. So the reference that was made was related to the timeline, because there was a lot of disputes related to it. In fact, there have been number of cases also in the last 2-3 years related to the governor's power. It has also been questioned in the Supreme Court that can the governor take unlimited time? And that is basically what was asked, that can the court impose any kind of timeline for the president or the governor to decide their opinion related to the bills passed by the legislature. And what we are about to discuss is basically in this very context. Okay. So first of all, let's try and understand what exactly is this advisory jurisdiction. Okay. So what exactly is this advisory jurisdiction concept? So advisory jurisdiction is under Article 143 of the Indian Constitution. What does Article 143 say? Article 143 says that the president has the power to consult the Supreme Court. That means the president can ask the Supreme Court for an advice on any matter which is either of a law, or the matter is it questions a law, or if it is a matter of public importance, then the president may refer the matter to the Supreme Court. Okay. Now, when it comes to the Supreme Court under Article 143, it is not mandatory for the Supreme Court to provide its advice. The Supreme Court can either accept and provide advice or may refuse to tender any advice to the president. So that is also there. And any advice that is given by the Supreme Court. So if the Supreme Court gives an advice, the advice that is there, it is only what? It is only, it's only an advice. It's not mandatory. However, one very important aspect of it is, which is also important for your prelims examination, is the fact that whenever the president seeks an advice from the Supreme Court, if there is an advice which has to do with a pre-constitutional treaty or a pre-constitutional agreement, or any such instrument which is pre-constitutional in nature, then the Supreme Court, it becomes mandatory for the Supreme Court to do what? It becomes mandatory for the Supreme Court to give their advice. Okay. So this is what Article 143 of the Indian Constitution is. And accordingly, this advisory jurisdiction, it was referred by the president asked that, and accordingly the Supreme Court this time did provide for that very advice. So what exactly is the Supreme Court's idea here? Let's try and discuss that part. See, the Supreme Court bench, which was headed by the Chief Justice of India, was responding to 14 questions which were issued by the president. And if you look at the questions that were there, it was primarily related to what? It was primarily related to Supreme Court's opinion on whether a timeline can be imposed on governor or the president for granting assent to the state bills. Can there be a timeline imposed? Okay. Now, what was the observation of the court? Let's try and understand this, because this I'll come to it. Okay. First, governor's discretion. So the Supreme Court very clearly says that when it comes to Article 200 of the Indian Constitution, that is, of course, related to the bills that are passed by the state legislature going to the governor, it is governor's discretion to decide on the bill, which means governor is not necessarily to act on the aid and advice of the Council of Ministers, and it is the governor which is to decide on it. So it is governor's discretion. Okay. Second, with respect to timelines, Article 200 and 201 of the Constitution allows for elasticity. So imposition of a timeline strictly is contrary to the Constitution. This is basically what the Supreme Court's observation is. Very, very important. That if you look at the Constitution, why has the Constitution not mentioned any timeline? Why did the Constitution did not say maybe 3 months, 2 months, 6 months, whatever? Because the Constitution subscribes to the principle of elasticity. That means allowing a specific elastic period of time for the governor or the president to decide on that matter. So if there is a time boundation that is imposed, that may be contrary to what the Constitution, the principle of the Constitution is. Okay. Thirdly, deemed assent. That means, suppose the president or the governor is not taking a decision on a particular bill, can it be deemed as an assent? That means, can it be assumed that they have given an assent? And the Supreme Court in that case also says no, that if we assume the concept of deemed assent, that again may be against the spirit of the Constitution. Not only against the spirit of the Constitution, but also against the spirit of separation of powers. You cannot assume that because the governor has not returned the bill, the governor has not decided on a bill, or the president has not decided on a bill, you cannot assume that they have given their assent to the bill. Okay. Thirdly, legislative process. A law made by the state legislature cannot come into force without the assent of the governor. So the Supreme Court is also very clear that there cannot be any mechanism where if the governor has not given an assent, the bill will become a law. No, it cannot be done. Then comes justiciability. Now, what is this? The discharge of functions by the governor or the president is not justiciable, and judicial review can be evoked only when the bill becomes a law. That means if the bill has not yet become the law, in that case the bill or the action of the governor or the president is not subject to judicial review. Only when the bill has been passed by the legislature, the governor, the president has given assent on it, and then now the provision of judicial review comes, not before it. Okay. The Supreme Court has also mentioned that part. Okay. So we have seen what Article 143 is. We have seen some observations. Look at this. There are some other observations also, like delaying the bill. So the Supreme Court has also been very clear related to the governor, and it has made an observation that the governor cannot use their discretionary powers to resort to prolonged and evasive constitutional inaction, which simply means that the governor should not deliberately not take a decision on it. This should not be the case. Okay. Though it is a discretion of the governor, but the governor should refrain from taking deliberately not taking a decision on a specific bill that has been passed by the state legislature. That should also not be there. Limited mandamus. Now, we know what mandamus is, and we know that mandamus is a writ which the higher judiciary in India, that is the Supreme Court and the High Court, enjoy, which can do what? Which can uh, command any public official or a public authority to perform its actions. Okay. Limited mandamus means what? If there is a prolonged or unexplained delay by the governor that frustrates the legislative process, then the court may exercise limited power of judicial review, not otherwise. But if suppose there is a case where the governor is not taking any action, and this inaction may frustrate or may somehow become a problem in the legislative process, then judicial review can be taken up. However, the judicial review can be taken up, and the governor can be directed that within a reasonable time bound manner he should be taking the decisions. Checks and balance. Constitutional authority function like an independent cog in the clock, which with checks and balance essential to prevent paralysis. Such a constitutional scheme abhors inaction. That means, in simple sense, the constitution principle that is there, it abides by checks and balance. That is basically what it is trying to say. This is the observation of the Supreme Court. Okay. Now, the question is, why has the Supreme Court deliberated on this issue? So you will find, as it is mentioned here, that the case of Tamil Nadu versus the state of Tamil Nadu versus the governor of Tamil Nadu, this particular case that was there, this was the case in which there was some specific timelines that were being deliberated upon and talked about, that governor should within this particular timeline give assent to the bill and all of this. Okay, so that was the reason why this was referred to the Supreme Court. Okay, so what is the observation of the Supreme Court? We have seen that as well. Now, when we say now, what is the implication of this? So the Supreme Court has made an observation. What is an implication? First, separation of powers. Very, very important. See, in India, one thing that has number of times be questioned upon, and just going back a few months back, the former Rajya Sabha chairman and vice president, Shri Jagdeep Dhankad, he also questioned on the very idea of the judiciary to question each and every decision that is being taken by the executive or by the legislature. And there also he talked about separation of powers. Okay, so here what you have to understand is that there is a separation of powers, and that separation of power should be protected, whether it is the powers between the executive and the legislature. Though India, being a parliamentary setup, does not have a clear separation between executive and legislature, but still, to what extent? And also when it comes to the judiciary, there should be a separation of powers. That has been what has been emphasized on. Secondly, legislative process. That means, though they rejected though the Supreme Court rejected any fixed timelines, but the court also is very much of the opinion that there should not be any kind of malified or indefinitely inaction. That should also not be the case, and hence a limited mandamus, that right has been kept by the court. Thirdly, federalism. The Supreme Court has rejected fixed timelines for granting assent to the state bills. However, the judgment reaffirmed that the governor are bound by the spirit of cooperative federalism, which means there should not be, the position of the governor should not be used or misused for the center to impose on the states. That should also not happen. Okay. Next. Tamil Nadu case, we have just understood what the Tamil Nadu case was about. So you can see, since the discharge by the Supreme Court of its role under Article 143 does not constitute judicial adjudication. It does not directly affect the judgment. As I've already told you, that it is not binding. So the April 2025 judgment that was there related to the timeline, that does not, it is not affected by it. However, the union government may use it as an authoritative opinion of the Supreme Court. So the union government will use it or can use it in order to further just continue with how the things were earlier, where the governor, the position of the governor has been used multiple times not to decide on a bill. So that will continue. That possibly may happen. Judicial appeals, because the Supreme Court judgment had set a precedent for the government, a precedent for the government to take presidential reference route against an uncomfortable Supreme Court judgment in further, rather than opting for file review or curative petition, which means that this is going to happen. This means that now multiple times you will find that Article 143 is going to be used, rather than after a Supreme Court decision, rather than filing for petitions like the curative petition or a review petition on a decision of the court, there it may so happen that Article 143 is used. Okay. Next, what is the way forward? Constitutional amendment. There is a possibility that there is a constitutional amendment that may be done to provide clarification related to it. Okay. So, in order to remove ambiguity, constitutional amendments can provide what would be the provision here. Secondly, judicial protocol. The Supreme Court may prepare a brief guidelines. The Supreme Court may prepare a brief guideline clarifying when the exercise of a limited mandamus is appropriate under the court's existing powers. As we have already seen, the Supreme Court has accepted the principle of limited mandamus in case of governor or in case of the president. So in that case, the Supreme Court may prepare the Supreme Court should prepare a specific guidelines as to when the limited mandamus can be used by the court. Then comes limit misuse of presidential references. Okay, it limits misuse. The Supreme Court can also clarify the situation where president's reference should be used or not should be used. Then comes depoliticize office of the governor, one of the most important questions that we have been deliberating upon since the late 1960s and early 1970s itself, the need to depoliticize the office of the governor. And parliamentary oversight. It may so happen that Parliament's role can be strengthened over the use of this power related to the governor or the president. Okay, these can be the way forward in order to address the issue that is there between the center and the state, and between the office of the governor and the council of ministers at the state level. Okay, a very important question. We dealt with it, a very important topic. Now we have clarified multiple things here. We have talked about the role of governor. We have talked about the discretionary power of the governor. We have addressed the Article 143 of the Constitution and the advisory jurisdiction part. We in fact also talked about the writ of mandamus on it. Okay, that's it for this. We'll meet soon with the next topic. Thank you.